Greetings, pairs, orbits, and retrogrades. Today, I have a special guest, Dr. Hadley Arkes, who it was for 50 years the Ney Professor of Jurisprudence. Now he's the Emeritus Professor at Amherst College, and he's escaped his time there. Recently, he's set up in Washington, D.C., a center for the study in natural law jurisprudence, which is a new approach to conservative judging, especially conservative federal judging, that Dr. Arkes is heading up. We're going to be having an important discussion between and among conservative Catholics today about how conservative judging ought to work as we move from the post-disaster era, hopefully into a new springtime of Catholic conservative jurisprudence. Importantly, Dr. Arkes was the main advocate and architect of the Born Alive Infants Protection Act, the main author on it, as I understand it. The account of his experience of moving the bill through Congress is contained in his book, Natural Rights and the Rights to Choose. Professor Arkes led the testimony on the bill before the Judiciary Committee, the U.S. House of Representatives, back in July of 2000, when I was still a young buck. And then he did so again in July of 2001. In 2002, President Bush signed the bill into law with Professor Arkes in attendance. You are truly one of the OGs of the anti-abortion movement, and you deserve serious plaudits, and it's an honor to have you today, Dr. Hadley Arkes. Thanks for joining me.
As one interviewer in Detroit said 40 years ago, folks, you got to understand, he's a very famous man in certain restricted circles.
Yeah, we call it micro celebrity, Dr. Arkes. If I go anywhere across this land or even Europe, and I go set foot in a Latin mass, it's a very, very big deal. And then
people recognize you.
Yeah, but if I set foot outside of that Latin mass and I go across the street, nary a prayer. So it's what Patrick Coffin calls micro celebrity.
Okay.
And it goes to, even micro celebrity goes to some people's heads, Dr. Arkes. Never let it go.
One of whom I am which. Okay. Go ahead.
Well, thank you for joining me today. There's a number. I've wanted to talk to you since I told you this. I'd read your pieces in the Claremont Review of Books, and I've read some of your other stuff as well. Back when I was a philosophy grad student overseas, and I was just, I was studying in Rome at a pontifical school, and I was just glad to be able to get my Claremont Review of Books, who somehow redirected my quarterly magazine. It's a big magazine there to my address in Rome. I'd read that starting in 2006. So that's really where I became acquainted with your work. And again, it's an honor to have you on the show today.
So dear of you to have me, Tim.
So the first chapter of one of your books, it's your latest book, is called The Natural Law Challenge. And I want to talk to you about this. I'm going to read a clip from, I think it's chapter 1 of the same book, The Natural Law Challenge. Truly, truly, I say unto ye all, parish orphans and retrogrades who are listening, the natural law provides a veritable challenge for folks because, as Justice Scalia would often joke, Justice Thomas, because nobody can disagree about what the natural law means, right? And he's being sarcastic the way he was 95% of the time. The point is this: the natural law is specifically what Augustine called the book of nature. You can read the book of Scripture and it's codified. It sets out and promulgates relatively articulate law. Well, there's law that accords with the book of nature as well. And let me read a quote from the very start of your latest book, Dr. Arkes. It's a Cicero quote. He says, "There will not be different laws at Rome and at Athens, or different laws now and in the future, but one eternal and unchangeable law will be valid for all nations and all times." And you identify this, either before or after the quote, as the loftiest hopes for the natural law. And this is where you're setting out what the natural law challenge is. I would say, as a Thomist, I would understand this could easily become the loftiest hopes for something like globalism. I would say as a Thomist that it's easy for natural law to be understood as a kind of utopianism. And yeah, so I want to give you a chance to say, why is Cicero right here? Do you think that the natural law should lead to a kind of universal positive law that perfectly reflects the eternal law? Because this is what neither of us are leftists, but this is what leftist critics will always say, and even some right-wing critics are concerned that it fails to differentiate the way Aristotle, Thomas, Bellarmine, Suarez will all differentiate. There will be a different law in different nations, even if we're talking about two different nations that are relatively different before the natural law.
Sure. Look, Thomas understood that we have to move the natural law to translate the law into terms of the positive law that bear on the situation before it. As Kant would say, before you have a law, say, 65 miles an hour, 35 miles an hour for winding road, there's a deeper natural law that tells you why you'd be justified in having a law that restrains the freedom of people to drive at speeds that put your innocent life at hazard. So we understand you have to make the transition from the natural law to some regulations that bear on the circumstances and the conditions before you. That will be the same in all places. Look, Lincoln understood that the case against human beings ruling human beings as though they're dogs and horses will be the same wherever the difference between human beings and animals, that natural difference remains. Remember the old saying was, no man is by nature the rule of other men the way that God is by nature the rule of men. Men are by nature the rule of dogs and horses. Okay. He understood it, but he understood that this is not be understood all over. And there'll be people responding to different conditions. It may take a long while working to them. And we can't impose that. What we can do is teach. We say if you come across people who haven't quite understood the Pythagorean theorem, it doesn't suggest there's anything wrong with the Pythagorean theorem. Things that people place are slower. But let's say we trace things back to some of those anchoring first principles, what have to be grasped, as Aquinas would say, those things we grasp per se noted, like two contradictory propositions both cannot be true. And as you know, one of the things I say we grasp in that way is that first principle of moral judgment is understood by Thomas Reid, I think by Aquinas too, actually, that it makes no sense to cast moral judgments of praise or blame on people for things they were powerless to affect. And Reid says that is true as any axiom in Euclid. But let's say, it's not a theory. I don't have a theory about two contradictory propositions both cannot be true. I don't have a theory about it is wrong to hold people blameworthy for acts they're powerless to affect. Where in the world would that be true? Anywhere. As Aquinas says, the divine law we know through revelation, but the natural law we know through that reasoning that is accessible to human beings as human beings. So if we grasp that, of course it's going to be true universally. We can't account on other people in other places arranging their sensibilities and their education to absorb these things. We can't. So that's just a hard fact of life. Now, okay, but go back to your point.
No, don't ever worry about taking too much time, but it's probably incumbent on me to interject here. A Thomist understands from questions 90 to 108
right
in the Summa there, treatise on law, that the natural law is a smaller subset of eternal law. It's not supposed to perfectly reduplicate it. As you go from divine law, eternal law, to natural law, to positive law, you're getting smaller and smaller funnels. And it's not a constitution rendering system. It's not something that's lost in translation from natural law to positive law. It's not a problem of efficiency that there will be moral conditions that are shorn off as we move from eternal law downward to positive law. In other words, it's a smaller subset of eternal law, the natural law is, and a smaller subset that gets instantiated in different ways within different cultures, even for Aquinas, who thinks the cultures are two of the highest sorts of regime. So this Thomistic principle is anything but relativism. And there have been times where I've debated natural law jurisprudence. One is some species of a natural law jurisprudence, Josh Hammer. I debated him in person. And I'm a Catholic scholar. I'm a Catholic philosopher. And I'm saying I think what often gets exaggerated or misunderstood by natural law jurisprudence is that what Thomas's basic principle, not all virtue should be mandated and not all vice should be proscribed. This is not what he advocated for. Thomas said in some places it would be best for prostitution even to be legal, and that's because prudence is the ruler's virtue. And once again, not all virtue should be mandated, not all vice should be prescribed. There's also the issue to hold, as Thomas does, that not all virtue should be mandated, not all vice should be prescribed, simply accords with an earlier Aristotelian principle that the law, which is a composite of physis and nomos, right, nature and convention, the law is a tangle of these two things, will only be mistaken as all physis or all nomos, all one or the other, by fools or something like that. And I guess the final principle, the final objection that I've had in past where I've done debates with either Patrick Deneen or Josh Hammer, was that for Thomas, not all even mortal sin is a violation of the natural law. And that seems to be, that's definitely what Patrick Deneen seemed to think. Like Thomas gives the specific example of bigamy, right? Mortal sin now, or and many of the sexual sins besides those ones we designate rainbow Skittles. They're mortal sins, but they're not violative of the natural law, because how could they be? It was allowed to Abraham.
Well, let's get into with you're right, with Aquinas. Aquinas says the purpose of the law is to lead people to virtue, not suddenly, but gradually. And what was that critical line? You cannot impose on the bulk of ordinary people the burdens of those who are already virtuous. Or else it's like pouring new wine into old bottles. Bottles will break, and those things will run out. So he understands not everything we could judge as wrong, we may be prudent in making illegal. For example, right now, we have a pretty subtle understanding in the law about the wrong of drawing moral inferences about people, creating disabilities based on race. We have never, contrary to what the Supreme Court, we have never applied, there's nothing in the executive orders or statutes barring people from discriminating on the basis of race in the choice of a partner for sex or marriage. There's nothing in the laws about that. And years ago, when this came up, there was the personal notices in the New York Review of Books, SWM seeking SWF, single white male seeking equal with female. And you know the New York Review of Books would never do an ad saying white landlord seeking white tenant. In other words, the understanding seemed to be that even in the vanguard of the left, the positive law has not reached that issue. It could be right in principle, other people not. But this gets into, say Lincoln, his understanding about the laws barring interracial marriage. He said there's no way he could survive as a politician in Illinois in the 1850s if he challenged those laws that barred marriage across racial lines. Maybe if you plant the principle, people work. And we have this in the pro-life movement now. We have the matter of abortion in case of rape or incest. And our position is that there's just a passion here. You may be asking us to give into this as a matter of truth, but don't you understand? We can't surrender the coherence of our argument. Our argument is predicated on the notion that that child in the womb is human from its first moments. Don't ask us to change that. You may ask us to make a prudential accommodation with a passion that is just overwhelming right now. And we may have to do that as a matter of prudence, but don't compel us to sign on to the validity of that thing. So yes, we know this happens all the time as people have to make their, and some things that we could judge to be wrong may not be prudent to enforce right now. But I think in any case, when you're passing a law, if you're neglecting to pass it, you should at least be clear on what the principle is that would justify that kind of a law if you made it, and then you give way on it. But no, yeah. Well, so anyway, I think you and I, as a colleague of mine, would say we're in heated agreement. But what you said something about things that are shorn off along the way, more things that are shorn off. What did you mean by that? Did you mean anything different from what I was just saying myself?
Well, Aquinas would say prescinded from, right? The natural law prescinds from eternal law / divine law. I won't trouble between the because it's a fourfold distinction between eternal law, divine law. That's less important for us now, but they're actually distinguishable. The eternal law prescinds from divine law. Natural law prescinds from eternal law, and positive law prescinds from the natural law. And folks, in my estimation, it's Straussians, particularly West Coast Straussians. A lot of times the people at Claremont Review of Books, followers of Harry Jaffa, who are not strictly speaking Thomists, will say, hey, we don't like the moral relativism of our day. We don't like what the left has done to jurisprudence, though I would say that's a competing conception of natural law jurisprudence the left has given us in the Warren courts, in the Burke courts. But we'll talk about that hopefully in a few minutes. But the natural law jurisprudence conception of relativism on the one hand and the natural law on the other hand seems to be that all virtue is mandated and that all vice is proscribed. And when you say, well, why did Thomas and the entire Aristotelian system set up a system which says precisely the opposite, that really the natural law is not a perfect reflection with only differences of inefficiency? Why is it not a perfect reflection of the eternal law? Why is it some of the biggest concepts there will be instructive within the law, but it's really not all of them? Why is prostitution maybe legalizable for Thomas Aquinas? This is actually what he said, in some cultures, but not in others, even though it's a mortal sin. What's the role of prudence in natural law jurisprudence that doesn't just leave it all to judicial discretion?
Well, I had a pointer that I've lost my hand, only bad handwriting. Just look at these matters of these prudential accommodations that we make with these things. Illegal abortions were still going on in Denmark, even if they were legal. Prostitution is legal in Nevada, but illegal prostitution still goes on there. We've just had this experience of making marijuana legal in California and New York. And what's been happening? The illegal network has expanded. First of all you've done, you've removed any sense of the moral wrong of it, the moral inhibition. So why the community objects to it. Once you've done that, it's simply a matter of getting it where you get the same better price that the illegal network in prostitution and in drugs can give it to you at a much better price. They don't have to deal with regulations, pay taxes, and so on. So yes, that may be interesting to say that we may have to make an accommodation. You discover, no, you can't make an accommodation with these things if you simply waive any moral concerns. We can understand in the past, prostitution, you're never going to, that was the funny one. Aquinas said, we cannot purge all evil from the world, from our lives. And to purge all evil from all vice from our lives would require a government that none of us could put up with, right? But what you discover is you may have to live with things, a law that makes prostitution illegal, and you just have to deal with it at the edges. Or Frank O'Connor, when he was DA of New York, there were no strict laws in it, but when he discovered a lawyer in Park Avenue doing abortions, there'd be a zinger. He'd do something about that, just to make the point. So at some point, the prudential thing is to live with this, but with a paper brown bag, and letting people go under the counter for these things. and but at least preserve the sense that overall we do think there's something unsavory and not quite fit for decent people. Don't remove that. If that is removed, you'll get just far more of these vices. Aquinas didn't have as much experience in dealing with these things, regrettably, as we've had over the last 150, 200 years. And we discovered, no, the critical point is not waiving entirely the sense that there may be something wrong here. Let that be hovering, even though it's impossible to enforce a law of prostitution perfectly.
Yeah, so I don't think it's just a question of perfection. That's one of the areas where we probably disagree the most. Like, think about it this way. Dobbs versus Jackson Women's Health, nearly celebrating its first year anniversary, vastly underemphasized in its importance. People celebrate it a little bit, but you're one of the heroes. As far as I'm concerned, Dr. Arkes, you are one of the 5 to 10 foremost heroes of the Dobbs decision. And I know you're a humble man, so you'll say, well, there are lots of important anti-abortion heroes. There are, but you're one of the foremost ones. Dobbs, I mean that as sincerely as could be meant. I've been anti-abortion my entire life since I learned there was such a thing in kindergarten. But, you know, my apostolate, my ministry here, if you will, roots on the pro-abortion people. I've lent my voice and even my signature to things that happen in the Catholic world, and I've helped to shape some of the arguments for Dobbs, you know, on my shows. But you were actually there in the battle, so that's amazing. But here's the thing: Dobbs was an ultimate vindication of originalism, right? I mean, like, literally, when a judge makes a law that is violative of the morality that actually adheres in American law. I'm not a positivist, right? When a judge violates the actual morality that was meant to be baked into the law by a legislature, it can be checked later. The math can be checked later, and it can be pulled out. And that's what happened with Roe versus Wade. But the irony with Roe versus Wade, kind of, which people out there need to be really clear. Roe versus Wade did not legalize abortion. It federally, because all of our disagreements are between the Fed and the state, I think, yours and mine, Dr. Arkes. It federally made it illegal for states to ban abortion. And this came from, and that was in 1973, of course. This all kind of began, it's all the 14th Amendment, which is the bitter irony in this, is that that's the work product of Lincoln, having the Fed interfere in the moral authority of the states, for better or for worse. So you get, in 1965, with 14th Amendment jurisprudence, you have the Fed making it illegal for states to ban contraception. They were oppressing red states who didn't like contraception. 4 years later, in Stanley versus Georgia, you have a 14th Amendment case making it illegal federally for all states to ban pornography, and it's red states that are being oppressed. 4 years later, you have Roe versus Wade. The Fed makes it illegal for states to ban, conservative states to ban abortion. Then you have toss in, 30 years later, Lawrence versus Texas, where the Fed makes it illegal for the red states to ban sod, we call Skittles. And then 10 years after that, the Fed makes it illegal for red states, and all states, but it'll only be the red states, to ban marriage between a couple of dudes. And then, of course, you have Bostock a little less than 10 years after that, which is not technically a 14th Amendment case, but it builds on all the logic, the Lincolnian logic of those 14th Amendment cases. And I would just say nothing good ever happens when you have judges inserting their own conception of natural law morality into the law, whereas this is supposed to happen. I'm not a legal positivist believes there's no morality in the law. That ain't me. Morality is supposed to be inserted into the law at the level of state legislatures. Literally, that's codified in the Constitution. It's called the general police power of the state legislatures. It's adverted to there in the 10th Amendment. And it is the power to regulate health, safety, welfare, morals, and security, those 5 things. This is what I always say to people. Yes, I'm a judicial positivist because I believe in the separation of powers and I believe in the separation between Fed and state legislature, but I'm not a legal positivist. A legal positivist believes there's no morality in the law at all. I would say, how, if we look at Roe and Dobbs's overturn, how does this stand up to the idea that originalism vindicates itself on the basis of the separation of powers and the separation between state and Fed? Because I think that's what happened.
No, I think it's a failure of originalism here. When some of us, like Mike Newman and I, were working in the pro-life movement before Roe versus Wade, and the concern of our concern of the people marching was for the babies being dismembered and poisoned. That's not the way this matter was viewed by the conservative judges who struck this down. Roe did not really establish a right to abortion. It changed the culture. It converted abortion from being something discouraged, abhorred, forbidden, into something to be celebrated, approved, and promoted. All that the court did here was strike down the great white whale of Roe versus Wade while doing nothing with the underlying position. The problem could be seen in Kavanaugh's concurring opinion, where he says that, God, some people, pro-life, actually believe the fetus is human. He's saying this after it's been established in embryology for many years, that offspring in the womb has been anything other than human from its first moments. What the court does here is just overturns Roe versus Wade. Yeah, we think our work is done. We've overturned the precedent. You haven't done anything to challenge the premises on which it was based. The court will not even affirm that the child in the womb is a human being. If it had affirmed that, it would be sending matter back to the states in a wholly different way. If you say, we've established there's a human entity here, and your job is to figure out how the taking of this life can be reconciled with your own positive laws on the taking of human life. And if it established that, it would establish that, yes, it's a human life, and therefore the Congress or federal judges could intervene, as they intervened in the South in the 50s and 60s, when the protections of the law were being withdrawn from a whole class of human beings. The line was, my friends have held this, abortion is nowhere mentioned in the Constitution, therefore, federal judge has no ground in which to proclaim any rights emanating from the Constitution. But as Jerry Bradley and Bill Davis pointed out, the federal government had ample reason to be dealing with abortion as its business. They had to deal with abortion in military and diplomatic outposts abroad, abortion in the territories, abortion in the District of Columbia. And a year before Roe versus Wade, 2 years before, the court sustained the laws on abortion in the District of Columbia. What you've seen in Kavanaugh's opinion is the price that Sam Alito had to pay for that 5th vote. All he did was dispose of Roe. My hunch is that 25 years from now, we're going to see abortion still raging in California, Illinois, New York.
Of course.
People say, it was what a great job was done when yeah, but is that what it was supposed to do? Wasn't supposed to do something more? It wasn't supposed to lay the real 50 years ago, the lawyers from Texas in Roe drew an exquisite brief, drawing on the most updated findings in embryology to prove that child in the womb has never been anything less than human from its first moments, never been merely a part of the mother. The conservatives, the dissenters, never drew on that substantive material, and neither do my 6 friends who are the conservative majority in this case. And yet, not withdrawing on that does not put in place the most critical premise that the pro-life needs in the states as well as the city. So we're turning it to the states, saying some people think it's human life, and Brett Kavanaugh said it's a value. Say, how about let's take that up? Scalia says we just make a value adjustment whether we think it's human life. Is that it? A value adjustment? We started using value adjustment. We start speaking of things that stop speaking of right and wrong. I talked about things having value. Now, is that how we conceive this thing? As Harry Jaffa said, that Lincoln said, the question is whether the black man is or is not a human being. And Harry Jaffa said, that can't be a value judgment. Many people at the time did not think black people were human at the same level as other white people we know. Are we going to say the same thing about the child in the womb? What are we going to ask people to say, when does that child become human? What do you think? When is it important to you? And so a woman now in the blue states will say, look, this thing I value is taken away from me because 51% of people around me have a different value judgment, have a different belief, a belief of when human life begins. No, it's more than that. Kavanaugh and the court did not remove this from the realm of belief to establish the strong empirical ground to which we recognize that child in the womb is nothing less than a human being at any moment. And to that extent, it did not really give us what we needed. And at the same time, we have to say, where is this curious notion that this is going to be confined, that anybody, a battle over this, will confine her argument to the states? Look, at the very beginning of the regime, the Constitutional Convention, there's this colloquy with Roger Sherman and James Madison. And Sherman said, we've done all our work as long as we secure the powers of the government in foreign affairs and in defense. And Madison said, oh, no. It's the insecurity of private rights in the states that has brought, people are canceling debts in Massachusetts, the local demos, a tyrannical local majority. Well, they had the contracts clause. But with the 14th Amendment, we had the power of a national government to protect those black people freed from slavery, to protect black people when the laws, the protection of laws were withdrawn, and protect unborn children now. And we know this is the way this thing works. You have a topless bar set up, the local community bans it, and what do people do? They go to a federal court to try to bring to their side a more libertarian kind of law. This has become routine practices, as you know, Tim. Why did anyone think that once people think, women thought that something truly fundamental was going to be taken away from them, they would not, of course, appeal to the federal government and a Democratic Congress quite prepared to give them what they want. I wonder whoever talked us into this notion that the people who lose in this way are just going to confine themselves to the states and not make that appeal to the national government. It just runs counter to, of course, the principle of the Constitution and our own experience over the last 70 years.
But in Article 1, Section 10 of the original Constitution, there are clauses like the contracts clause, very, very few points where the state will be subject to the Fed, right? The contracts clause is one of them. That's why it was addressed at the time. The problem with the 14th Amendment, on the other hand, which subverts the entire separation of powers in Articles 1, 2, and 3. The entire separation of powers was the notion that Article 1, Section 8 of the U.S. Constitution listed the 15 bare, not moral, unsexy legislative fields that the national legislature would hold over the state legislatures. The state legislatures would do all the moral legislating. That's guaranteed by the general police powers. I asked Josh Hammer this. He had to admit that's a state legislature thing, not a national legislature thing. The national legislature specifically only gets things like coining money, building postal roads. That was as deliberate as it can get, as deliberate as the separation of the powers in Article 1, legislature, Article 2, the executive, Article 3, the judiciary, is that topwise separation between state and Fed. And in the American system, we like all the moral legislation, all the moral legislating comes from the local people, which is what Leo the 13th loved so much about America.
I'm with you, and the courts have been removing critical powers to define marriage and so on. But look, first I got to recognize this problem of intervening in the states. This was baked into the government from the beginning. We have the guarantee clause. You cannot convert any government into a monarchy in the states. We are committed to the federal government to intervene when there's a danger of a coup within the states. The states may not make their territory available as a base for naval and military powers. That was cooked into the Constitution from the beginning. Now we simply exceed the expansion of those powers with authority, expanding a power that was there originally. Lincoln's line, who do you expect to repress the local mob? The sheriff elected by the local yahoos? Or may you require at times the intervention of a more distant government to do that? Now, the classic understanding, of course, the original argument against the Bill of Rights is that your rights extend far beyond the things in the Bill of Rights. You have a presumptive claim to all dimensions of your freedom. The burden falls with the government when they restrict that freedom. I'm with you. I think the courts have gone too far in really knocking down the powers of the government to take these more. It's as though it's the old Federalist anti-Federalist scheme. The anti-Federalists were the people who took seriously that these local governments were polis. That they have a serious concern for the moral character tradition of their people. But then again, understand, look, let's say, we bring it back to you, Tim. Let's say a local government decided, yeah, it is a value judgment of whether we can consider Black people to be human beings. It is a value judgment now as to whether we think that child in the womb is anything less than human. Is that not, it becomes legitimate under the case to say, okay, you're passing a law, you're restraining freedom. It is never out of season. It is implicit in the logic of a liberal government that we demand that people in authority justify these laws they're imposing. Now, I don't think you want to get yourself in the same business saying, when we're going to simply say, we're going to let people decide whether on this matter of value judgment, they think that thing in the womb is a human with any claim to their, is that really a value judgment? Or do we have not some ground for calling it into question and demanding raising more demanding questions about it and a challenge to it? And you could do it now, yes, with the federal courts.
I want to address a couple things that you said earlier, under the heading of the first principle for a Catholic of government, which is subsidiarity, which is that it is a grave evil. Pius XI calls it a grave evil for a further away sphere of government to do what is in the generic competency of a local one, a more local one to do. The generic competency, meaning if it's within the power of that government to do it, and that's always local government, because, you know, from Honolulu to DC, that's 5,000, that's a world away. No government can really be done. You know, the idea of a hemisphere-sized republic is anathema to Aristotle, Augustine, Aquinas, Montesquieu, everyone in between. This is why all governing must be done locally. Like you said, well, as if this were a challenge to my view of the US Constitution or my view of the natural law. You said, well, abortion in 50 years will probably rage in California. I say, of course it will. Of course, abortion will rage in California until kingdom come, just as it will in China with their abortion policies, or in St. Paul's Day as it did in Corinth. That's not my concern. See, what's really my concern is my res publica, which is why I moved out of the state of California, which is their res publica. It's their problem now, just as in China, it's their problem. And the idea of virtual representation, carrying all the moral responsibility for formal cooperation with evil, is the notion, the attendant notion that once I move out of that res publica, it's not my problem. I'm half a world away. I'm 2,000 miles away in Mississippi. I don't like it. This seems so. I would say that this sticking point that I always have with natural law jurisprudence always comes down to subsidiarity, which is hashed out by a second problem, the division of powers with state rights. I'm not saying that the courts under the 14th Amendment went too far in federalizing everything. I'm saying that the 14th Amendment, in terms of giving us Roe, giving us Stanley versus Georgia, giving us Griswold versus Connecticut, Texas, Lawrence versus Texas, Obergefell, I'm saying it did precisely what separations of powers violations always do, which is to say they violate subsidiarity. You have a top-down government that's not a legislature, by the way. It's not a state legislature. doing what a state legislature should do. And it's a grave evil, as Pius XI identified violations of subsidiarity. And this is a violation of the natural law, because subsidiarity is part of the natural law itself. Dr. Arkes, like, who makes the call in a basketball game? The ref nearest the line or the ref across the field?
Yes, we think, as I used to say, no one is a moral relativist where he lives. These people take these things seriously, right? Okay.
Right.
It's not, but if this were a confederation, then it could be like the South. We say we're utterly indifferent as to whether a monarchy is established in any one of these. We are utterly indifferent about the nature of the regime. But this is a different regime. It was brought forth, as James Wilson said, not to invent new rights, but to secure and enlarge those rights we already have by nature. The right to life did not mean a right to life everlasting. It meant a government that would at least protect you from an unjustified assault on your life. Now, if you're telling us what you've got here is a situation in which California, New York, and Illinois can keep licensing the destruction of innocent beings, that is not the regime that was called forth in 1776 and 1787. That's not what we formed here. I don't think so. The question put up to you is, if in fact they come down now with the side that no, it's a matter of your value judgment as to whether you want to consider those big human beings. Are you actually saying that you're perfectly willing to live in a regime called a regime designed to secure natural rights, and somehow you think that the authority of the states is a real enclave tightly outside the principles that define the nature of that regime, including that the principle of protecting innocent life from unjustified assault? In other words, how do we get to that point of valuing that? It's like the Confederation. Let's just break it into, say, we're utterly indifferent to the nature of the regimes in these places. That's subsidiarity. That could be one form of subsidiarity. But is that the subsidiarity that we signed on to in this regime and this constitution?
Certainly. Well, we have two regimes. We have this is where our deepest disagreement, Venerable Dr. Arkes, is on Lincoln. We had the regime from 1788, which I read through every line of the Virginia ratification debates with all of those geniuses there at Richmond from June the 3rd to June 24th, 1788. And the terms on which these four of the first five presidents were Virginians, they very narrowly by 88 to 80 measure even ratified the Constitution from 1788 in summer to 1869, when we got the passage of the new Constitution, which is the 14th Amendment, which radically inverts subsidiarity. That was one regime. And from 1868, 1869 until now, and I'd say Roe versus Wade was created by Lincoln and the 14th Amendment, by the federal incursion into states' rights. The notion that I'd really like to interrogate for maybe the rest of our talk here is it possible to have one world government? I think you'd say no. Is it possible to have hemispheric government? I don't know, because that's the Lincolnian project, is the idea that there can be a res publica that is not circumscribed around the polis. Like all of our terms, I used to tell my students this, all of our terms in the realm of the political or even political oikonomia, oikonomia means the household. Polis, political, means the city. This is a natural law principle. You can only govern, not just as a matter of incentivization. You can only govern locally. You said no one is a relativist where he lives. I agree. As a matter of incentivization, that's true. But more importantly, as a matter of competency and ontology. The German term is Dasein, being there. Like the ref across the basketball court, not only, it's not an incentivization issue that renders him incompetent to make the call. It's a competency issue. It's an ontology issue. He's not there to make the call. Same thing with, I hire a babysitter when I take my wife out on a date. That's because it doesn't do to call in from the restaurant and talk to my twin 8-year-olds even once every 5 minutes, which wouldn't be any fun anyway, right? You have to actually be there or have a surrogate, a babysitter there. It's an ontology and competency issue.
Okay.
And no Republican theorist from Aristotle through Montesquieu, including the venerable Thomas, Bellarmine, Suarez, even Leo XIII, they were all popular sovereigntists. None of them thought that as a matter of the power coming from the people, Aquinas believed this, Suarez believed it. They didn't believe that the power could be inserted from the top, from some funnel like Washington, D.C., and then adjudicate matters either through the legislature or the judiciary as to what's going on 5,000 miles away in Honolulu. In other words, a res publica requires smallness, and all Madison's critiques of this in things like Federalist 10, which are taught in Straussian places like Hillsdale or Claremont, they never give you the response, which was a response also being published in the New York Gazette by guys like Brutus, Cato. Brutus's 4th and 6th letters, Cato's 3rd. I think they have the better end of the argument as to why Madison's inventing a worldwide or a hemispheric res publica, which is supposed to be the size of a city for ontological reasons.
There's so many things that, let me cut into where I do agree with you. But Tim, is there possible to get a break? I promised the plumber that we'd be finished by 1 p.m. and he's been knocking at the door. Can you give me a break just to see if he's there?
How long do you need? Yeah, because we're live here.
One minute.
Okay, 1 minute. Go. I'll talk here while we go. Thank you. So what's at odds here, folks, is not whether abortion is good or bad. It's not whether or not contraception is good or bad. It's not whether sodomy, gay marriage, or pornography is good or bad.
I'm back.
Okay, you're back. That was quick. I was just breaking.
The plumber has arrived, so we're in good shape. Look,
perfect. Let me go. Can I finish this thought, Dr. Arkes?
So many things here. I don't know where I'm going to cut into this, Tim. Go ahead.
Yeah, like I was just saying for the audience who are not jurisprudes, I was literally just recapping. I wasn't trying to get the upper hand. You and I agree. Abortion, sodomy, I'm going through the big 14th Amendment cases. Abortion, sodomy, gay marriage, pornography, and contraception are all moral evils. You and I also agree that they should be, they really should be adjudicated against. Like I'm not a legal positivist. I am not a legal positivist, folks, is one who believes there's really no morality in the law. It's strictly a logistical set of parameters that ought to matter. We agree about both those things. Take those 5 evils that come from these 5 cases that come from the 14th Amendment directly given to us.
They don't come from the 14th Amendment, and they don't come from the substantive due process. They come from simply false reasoning that should have been met at that level as false and dubious reasoning, that indefensible reasoning. That's how.
But they're decided on the legal theory of the 14th Amendment.
Let's go.
It would not have been possible. I'm talking about the cases: Roe versus Wade, Griswold versus Connecticut, Stanley versus Georgia, Lawrence versus Texas, and Obergefell v. Hodges. These 5 cases, which made it illegal for red states to illegalize these moral evils, which all of them, by the way, had been doing. All the red states had been illegalizing porn, contraception, sodomy, gay marriage, abortion, pornography, until the federal government, on this legal theory, which is how the court works. I could tell you as a lawyer, it literally came in and it said, okay, on the 14th Amendment, now that we have the federal government sticking its nose by the federal judiciary into the moralizing legislative powers of the state legislatures to tell them they can and cannot rule on certain things, we are literally making it illegal. We will use the Army or the National Reserve or whatever to come in and force these states, these red states, to not have these bans. We're banning the bans.
Okay, so, Tim, let me cut into this place where you and I, you don't see that you and I are in quite agreement. Russ Hittinger said that Lincoln could not have raised his hand on March 4th, 1861, and promised to defend the Constitution if it really did incorporate the holding in the Dred Scott decision that people may not be deprived of their property and slaves when they moved into territory. I have taken the line, the Lincolnian position. The court may articulate a position. They may decide that Dred Scott is a slave, but Lincoln says, we may have to accept the verdict in that case, but we're not obliged to respect the principle articulated in the case until we accept it. And he and his Congress voted to counter the Dred Scott decision through administrative action and legislation. It was entirely possible for a government here to have said, when the case came up in the NIH using fetal tissue, that the court decided Roe versus Wade, but the administration has never settled onto the principle there that you could destroy an innocent human life. So we may not follow that in this. I'm holding on to the Lincolnian position where political branches may counter, restrict, challenge, cut back, challenge the court by cutting back, as they did. Let's say when Lincoln came in, one of his first cases involved a Black student denied a patent, a passport to study in France. A Black inventor in Boston denied a patent on the premise that the Dred Scott case decided that Blacks cannot be citizens. The Lincoln administration issued the passport and the patent, said, in the understanding of this administration, all free Black people were in ours indeed citizens of the United States, anything in Dred Scott notwithstanding. So I'm the one who takes the line. In fact, we try to put this into the legislation. We said, if the court can articulate new rights, say right to abortion, found somewhere in the Constitution, the legislative branch must be able to vindicate the same right based on the same clause, and filling it out, marking their limits. The one thing that should not be tenable is that the court can articulate new rights and then assign to itself a monopoly of the legislative power. No, I don't think it's Lincoln and the 14th Amendment that gave us the travesty of striking out those laws on pornography, prostitution. And these are the products of people with defect, Republicans and Democrats from the best law school, absorbing libertarian premises. And those arguments should have been met at those terms. Here's Kennedy invoking autonomy. Anyone in the founding generation knows, and we speak of liberty, there's always a danger of license. The liberty is directed to a wrongful end. You cannot plausibly say, under the grounds of autonomy, I have the right to gay sex or destroy my. No, the question always has to be right. Why is that autonomy directed to a rightful end in protecting pornography, prostitution, and sodomy? That is how it should have been. People say, well, if it's not to, only I used to be that, well, this sodomy, well, it's not to my taste. Okay, they say, okay, I disagree with it. There's something wrong for me to think have an adverse judgment on it. And yet the argument came along. It's not a matter of taste. It's wrong for you to cast an adverse judgment. Why? Why is it wrong? I mean, these questions were not posed in a serious way. Judges who are connected with that tradition of natural law would not deal with it in such a flippant way. They'd say, you're making a powerful decision. You are now trying to sweep away the laws in the states that can counter this. It's incumbent on you to have a really compelling justification for what you're doing and not to skip around it by offering these slogans on autonomy and so on. It's not the 14th Amendment that's doing this. Lincoln could have handled these things quite well. It's not the 14th Amendment. It's not substantive due process. It's a result of people who've had judges who've been tutored in progressivism and liberalism.
There might be some sense in which a Catholic like you or I looks at the 5 cases in question that, as a matter of fact, made it illegal for red states who were illegalizing said vices: abortion, contraception, sodomy, abortion, pornography, gay marriage. They were already illegalizing them. The court came in using the legal theory, this is the way the cases were decided, and said it's now illegal from above, from the Fed, to illegalize these things. There might be some sense in which we could say, well, the real culprit is the fallen human nature. The real culprit is concupiscence, the real culprit is Adam and Eve. Fine, it's not the 14th Amendment in some mystery of iniquity way. There's enough people, even in those red states, that have used their sovereign police powers recognized by Leo XIII, Thomas Bellarmine Suarez. They've used their sovereign police powers of local government through the real natural law, which is subsidiarity. And they've said, these are bad for you. Pornography is bad for people. I think it's a worse evil to have legalized pornography than, I don't know, maybe it's as bad as abortion, but abortion is certainly worse than slavery. And we can rank these evils and say they're really bad. And I am not a legal positivist. I think they should be illegal. The question is, who has the authority to render them illegal? And the original Constitution, our first regime in this country before Lincoln changed it all around, was very clear. It's the police powers of the states. The states would act as Justice Jackson called them, the fora of experimentation. Your state is the place with which you share a kind of formal cooperation via the laws because it's local. Pius XI calls this subsidiarity. And yeah, if that's why I left California. I left before Dobbs came out. I don't want to be associated with all of the wackiness there, up to and including the fact that abortion will be illegal until kingdom come. Therefore, I left. And once all we need is for the federal government, the 14th Amendment, to get out, to give these powers back to the states. I view my real Republica, my res publica, as my state. And once the government is out, as a simple matter of fact, even if we say sin is the real culprit, Dr. Arkes, then if we would just do away with substantive due process, we could test this theory. Then all of the red states would illegalize all of these vices: pornography, contraception, abortion, and the rest of it.
Some would. Look, I think,
and that would be enough for me, right? I don't associate with blue state people. I left them. They're not my republic. That's why what we're really arguing about is the idea of whether or not pseudo-globalism, that is a hemispheric republic, which no Republican theorist ever said was a possibility, whether that's a possibility. I think that's always the Lincolnian question: is why would a federal nerve center from Washington, D.C. have the right to tell a Honolulu wheat farmer 5,000 miles away that they can't consume their own wheat, which is the Wickard v. Milburn case?
At the bottom of this, I think actually you have a problem dealing with exactly the question Lincoln was raising about the Constitution of the Confederate States. Look, back in September 10th, 2001, I was about to do, I was writing a piece, I thought, for the Wall Street Journal before the world changed the next day. There was a meeting in the UN in Durham, South Africa, which they claimed the right of the Palestinian people to, the inalienable right of the Palestinian people to a homeland. That's an inalienable right. That sounds like 1776. Were they really declaring the right of the people to have a government by the consent of the governed with free elections? That couldn't be what they're arguing in the UN, because that half the countries in the UN would fail by that test. What they're simply affirming was the right of people to have a land. So now Lincoln's raising this question. Let's say, he said, why this pressing out of the view of we the people? We the states, they say, not we the people. With we the people, the ground was, the anchoring principle is, we are establishing the right of a people, to human beings, to be governed with their own consent. Now let's say we move that out. You're removing that. What is the anchoring principle of the separate states to detach from this connection with the federal government? Would we simply be affirming the right of what most people want in the states to establish the character of the regime, no matter what it is, whether it's prostitution, pornography, abortion on demand? Are we simply affirming the right of a majority simply because they have the power? Or is there an anchoring principle here? If there is a principle, as there is, it would establish the ground on which the government in the state is not respecting the terms, the moral terms in which that state itself was constituted. I think that's the question we put before you. If those principles of natural law are not there as the very ground of the polity, that would also give you grounds on which to challenge, put a burden on the government at local level to establish why it's justified. If that's not there, then what is the moral ground for the regime as you describe it now in those separate states?
Well, there's no moral ground. I'm just citing Pius XI. There's no moral ground for some sort of global authority 5,000 miles away to legislate anything. That's a legal fiction. I would say the moral ground, any government governs its people, right? It's polis. It is literally a natural law principle that it must be nearby, not just for reasons.
What is the ground on which the local government rules? Is it on the ground that human beings are the bearer of these natural rights, that they have a claim to be governed only with their consent in a government restrained by the rule of law? Is that it, or is it something else? Because if that's it, then even those local governments are putting some serious. Well, look, we did not have a moral project, whatever this is in the United States. It was not a moral project. There were moral terms for the beginning.
Of course,
we know that.
We agree on that. So our trick here, I agree with you on most of them. I think the federal courts have swept away really critical things that we need. But the point is, if that's not the ground, what is the ground on which we're establishing the sovereignty of these separate units then, detached from that moral purpose, those moral terms that establish the terms of which we are coming together as a people? It all boils down to a connection between ontology and demographics, right?
Okay.
Plato said that the ideal polity is 100,000 people. Aristotle says it's 50,000 people. This runs like a thin blue line through the entire tradition of what a res publica is. Aristotle said there are three valid regimes, right? And each valid regime can be inverted and subverted. Well, from Cicero, Seneca, Augustine, they're all taking on board the presupposition that republics will be small. Even when Rome got corrupted, it moved from a small republic into an empire. As this moves through the Holy Roman Empire, which still honored the principle of subsidiarity, you get Aquinas, then you get the real political thinkers, Bellarmine, Suarez. They're all assuming that out of the Republican intellectual tradition, republics are political, meaning they involve the city, like literally a larger city or a smaller city. They come from the city. Montesquieu, who the Federalists and the Anti-Federalists were banding in the summers of 1787 and 88, but only the Anti-Federalists were actually honoring him because they were saying, look, he had three big cardinal rules. And the first two of them are a republic must always be univocal. It must, in order for there to be a res publica, like St. Augustine said, it must be a thing held in common that everyone believes in. Therefore, pluralism is not an existent thing capable of existing in a republic. If you want to keep ideology pure, you have to keep, most of the time, religion pure. Ethnicity typically follows this. That's what a res publica is. And if you want to keep it pure, you have to keep it small. That's Montesquieu's rule number 2. He's looking at all the republics of all time, from the Greek polises to Little Malta to even the rather big res publica of Magna Carta England. And all the framers are talking about this at Richmond too, by the way, to the Venetian Republic, to the Swiss cantons. And there's something they all had in common. There's not one exception, Dr. Arkes. It's that they're demographically and they're geographically small. A hemisphere-sized republic is a contradiction in terms until this thing attempted to be reified by the likes of Madison in Federalist 10. That was 13 states. Once Jefferson purchased Louisiana and it became a 50-state proposition, it's a hemisphere. And Lincoln, that's fine. I'm fine with saying Lincoln inherited this problem, a 50-state Leviathan. It's globalism at that point. And all of the moral legislation breaks down when it's a grave evil, according to Pius XI. That's what I would say.
Look, Tim, I'm with you so much. We take citizenship. A polis is not simply like a hotel you check in and out of. There are moral terms for this. Yes, it's reasonable to ask people coming to the country, do you accept these terms? Do you understand that you're not free to vote for a Castroid party that would end the government of free elect? It's legitimate to make people attentive to those things. But look, you said it's a republic. Is it a race public? Is it a republic? Can it turn itself into something else? Could it be a monarchy? Could it be an authoritarian? Could it be a totalitarian system and still meet your definition? Well, let's say, yeah, we can do this. We could have a confederation again, which people could have entirely different systems with simply a confederation, a league of people who simply are merging for self-defense, perhaps. We could do that. We could, that's not what we have. So let's say in one of the, I just want to say, in one of these states, they actually come forth with a policy of compulsory abortion. They follow China and compulsory abortion. Does that fit the terms of what you would imagine a race publican to be, even in these separate units?
It fits the terms of what I'd say a continent-sized non-republic would do. All violations of subsidiarity will
let's say it's
immoral.
Let's say it's your way. You've got California now, a really self-governing place, and they decide that for the sake of the population problem and climate change, we are going to follow China for a while and reduce and allow only one live birth of a family. If they did something like that, is that still up and open to no challenge within the regime as you'd understand it now?
No, I just wouldn't live there. No, that wouldn't qualify. I mean, by the way, I think California's far too big. California, if you absent the blight on the contradiction in terms definition of res publica that America attempted to inform, then California by itself, taken as a res publica, would still be like the biggest republic in the 2,500 year.
But are you saying if you had compulsory abortion in California, they'd say it is still part of the union that we thought we were establishing and preserving in this country? It still fits the moral terms of what we thought we had here. I mean, are you willing to say that?
No, well, I know, like I said, we're in a second regime. Well, the regime changed after the Civil War.
Let's say it was the way. Let's say it is the way you wanted it, and at that time, the people were not clear that blacks really were human beings. They can make their own decisions of the state. Let's say right now it's possible, just as New York and California are saying that the right to abortion does not end even after the child is born. These guys can go crazy over climate change and say, no, we should have compulsory abortion. And I don't see how the question is, that really, that state of affairs within this, is that really compatible with anything we thought of when creating this union, even as we try to preserve, and I agree with you on this one, even as we try to preserve the widest latitude for the states to make serious moral judgments and kind of life they want to preserve among their people. Still, is something like this just not beyond the level of the terms of what we thought we were establishing in this kind of regime?
Could you refine for me, please, Dr. Arkes, the call of the question? Because I feel like I feel like the question is making my point, but maybe I'm misunderstanding. I don't think any theorist in the Republican tradition, there's not one that holds that you will get anything other than moral depredations by having global, otherworldly government.
I'm with you, but you're talking about what you would have instantiated in these United States. Yeah, a big country, and you have California is a big state, but if it goes off and be that self-regulating republic, as you have in mind, not the federal government intervening. They could go ahead, put abortion to the last minute, even after the child is born.
Yeah.
They're free to do that kind of, and they have compulsory abortion, even within this complex of this union. I mean, I can't believe you'll be, I don't want to put words in your mouth, but is that really compatible with anything you see as the moral terms on which this regime was established? Even though we could see that you and I wanted a much wider range of freedom for local governments in making some very tough decisions, even when they run counter to some of the liberal sensibilities of the time. Is there not some limit to that, some moral limit that would restrain the self-regulating public in California to saying, no, not compulsory abortion?
Absolutely. I'm perfectly, and it's not, if we, I'm going to make an answer to your question, but give me a way to make a chronological trifurcation here. You're saying under this regime, according to me, and according to people that take subsidiarity very, very seriously as the first principle of government, according to Pius XII, this regime began in 1868. So you could say this is American regime. I was going to say American regime too, but for the purposes of distinguishing an earlier point you made, the Confederation point, let's call it regime number 3. Okay, it begins in 1868, where the government, and it's really the federal judiciary, steals from from state legislatures the GPP, the general police power. I'm just writing these things down so they're organized in my head. In regime 3, beginning in 1868, with the passage of the 14th Amendment, which legally anyway gave us all of those depredations we were talking about in the Warren Court, the general police power transferred in the 14th Amendment. This is just a simple matter of constitutional history. It transferred from state legislatures, the ability to the sole discretion of state legislatures, whether they're 13 state legislatures or 50 after the Louisiana Purchase, to regulate health, safety, welfare, morals, security. The moral legislation power transferred in regime 3 in 1868 to really the national judiciary. But in regime 2, which began in 1788, we had the passage of a new constitution, which was not about confederations. It was a very careful balance of what Madison says this in Federalist 39, a balance between a confederation, there were elements of it that were confederated, and a consolidation. It was supposed to be half-half.
Right.
It was clear one would preponderate, but it was not pure confederation. I'll give you that. Under the new constitution, where the most important thing we're arguing here is the GPP, the general police power, perfectly crystal clearly resided in the states. And in the several states, whether 13 or 50, the general police power to regulate health, safety, welfare, morals, security was something that adhered in the state legislatures, and it wouldn't be transferred de facto to the national judiciary until that third regime took effect with the passage of the 14th Amendment, Lincoln's legacy in 1868. I would say I'm comfortable with regime 2 as long as you could keep it. Remember that old Benjamin Franklin line, right? As long as they could keep it.
Regime 2 meaning what? 1788 or 1868?
1788. 1868, I'm saying this is, expect what you get here. When you do violations of subsidiarity, where there's a moralizing legislative power from 5,000 miles away, that's globalism. That's what I'd say. But 1788, the non-pure confederated government, that's regime 2. If you could keep the general police power in the state legislatures, yes, I'm perfectly clear to answer the call of your question, with the state legislatures being 13 or 50 different forums of experimentation. And so another state can do stuff that I think is heinous, right? But I would mark off as 1776, the passage of the Articles of Confederation, as regime 1 that only lasted 12 years. I would also be very comfortable under the Articles of Confederation, which is So what we have here is regime one is Articles of Confederation. It's one branch government. All of the terms like FOTUS, from which we get the term treaty, this is a term comes directly from sovereign international immunity principles, meaning 13 separate nations banding together to fight a war. Same thing with the term Congress is a sovereign international immunities principle term. Tolkien uses a term like moot and moot. This is another term that means separate countries, which is why the S in states was capitalized. Even under regime 2 in the 1788 Constitution, it was. They were like 13 separate countries. They didn't have a national judiciary or a national executive. They only met once a year in the summertime. They had this Congress, which is sovereign international immunity principle. It was really signaling this is pure confederated government, regime 1 under the Articles. And I would be very, very comfortable under that. Now, regime 3 is pure consolidated government, which is what you get with China or Russia, which is why people shouldn't be surprised that the 14th Amendment is used to make it illegal for little states like Mississippi to outlaw abortion, contraception, porn, sodomy, gay marriage. That's what you should always expect, says Pius XI, with violations of subsidiarity, when you get pure consolidated government. The American Empire after 1868, Soviet Russia, Red China, that's what you should expect. And then, but regime 2 is that attempt of a mixture, says Madison in Federalist number 39, between confederation, elements of regime 1, and consolidation, elements of regime 3. But it tipped, as the anti-federalists, particularly Mason, my favorite, George Mason is my favorite anti-federalist. He said it's going to tip one way or the other. This mix between confederated and consolidated, it's going to go one way or the other. It's probably going to go the way of consolidated unless we're really honest.
As Hamilton thought. But look, remember that beginning, that Constitution put many serious restrictions on the states. You may not convert this at your state into a monarchy. You may
in Article 1, Section 10. There's only a few.
Wait, go through it. You may not issue letters of nobility. You may not make something other than this coin, the standard of currency. You may not.
Agreed. That's all Article 1, Section 10.
You may not pass ex post facto law. The thing came along with all kinds of restrictions, saying what are the kinds of freedoms and procedures of law that we're trying to do. So it began in that way. And one of the
Article 1, Section 10. I'm not trying to interrupt you. I'm just saying all of the few things that the state legislatures couldn't do that the national legislature could was in the contracts clause. It's like 6 things. It's in Article 1, Section 10, following upon Article 1, Section 9 and Article 1, Section 8, which said the things that the national legislature, the Congress, could do. So the point is, according to that original regime, or I guess regime 2, the way I've drawn it up, it was very explicit. There is a general police power that does belong to the states. It's shored up not only by what is not given to the national legislature in Article 1, Section 8, but it's doubly shored up by the 10th Amendment 3 years later in 1791, where it says they will be retained. What's not given in Article 1, Section 8, what's not given to the national legislature will be retained by the states and the states' people. And that's been called, since judges named it that right away after 1791, the general police power. And so it's very clear the moral legislation in the 1788 Constitution comes 100% not from the judiciary, state or national. It comes from the state legislatures. And that is something that you were asking me, am I comfortable with the states being the forums of experimentation, even if it means
compulsory abortion?
Yeah, but I mean, they're not my republic. I am a states' rights guy. And
That's
just as,
I don't
like it, but I don't like compulsory abortion in China. California's China to me. It's half a world.
But it's not China. It is supposed to be part of an American regime, a constitutional republic. And there are moral terms that brought us together.
But they have to be kept small to be kept moral. That's the point. If you make it 400 million people, it's not a republic. It is China then. That's what I'm saying.
Look, Madison said, extending the sphere may make it just harder for any dominant interest to take over. It makes people put them under some kind of discipline of trying to justify their policies to people at odds with them. That is one thing. What we're suffering from are from judges who have been just too lax in the kind of restraints they're bringing forth, to principles they're bringing forth to judge these policies coming out of the states. It's simply a failure of wisdom, a failure to understand the original principles that's at work here. You had so many things I've been making notes about. We're saying I may be losing some of them. But you would be quite comfortable in the Confederation. Of course, the Confederation had a problem raising taxes. It had discriminatory tariffs going from one state to the other. You probably would not have been comfortable with that. But again, the problem is you're in this regime, which there are supposed to be moral tests. The judges have abused, they made serious mistakes along the way. Wisconsin decides that somebody who is neglected to pay his obligations in supporting the child probably should not have the freedom to marry again until he's under those. I think that was quite a defensible policy. The court struck that down for dubious reasons. That's the way it's been going. I see that you remember the old flag salute case with Jehovah's Witnesses? Felix Frankfurter first wrote a decision in Gobitis sustaining that power. And FDR thought it was a crazy law, but look, states should have the authority to do this. And Chief Justice Hughes said, yeah, they should have. They made a point that when the court struck that down, they went to the good decision. They were going to the aid of the Jehovah's Witnesses in West Virginia versus Barnett. But as Hughes pointed out, what you're saying is you're making this decision. You're withdrawing those powers of the legislature to cultivate patriotism in their separate. You've got to understand, it's a great book, it's a notable move, and you are undercutting the powers of the state legislatures to make those final decisions. I mean, I'm with you on these things, Tim, but the point is, there must be some minimal term. These governments were formed, so the Declaration, to defend us in those rights arising from nature, that human beings did not deserve to be ruled as human beings rule animals. That biped who conjugates, look, remember Lincoln's line about those slaves that didn't throw in with John Brown. They were illiterate, but they could see that the schemes of this crazy white man were not conducive to their well-being. They did not deserve to be annexed to the purposes of other men without their consent. That comes along, or Lincoln saying, no one made in the graven image was sent into this world to be imputed. That's where the religious tradition really comes in mind decisively to explain why that biped who conjugate verbs we see as a rights-bearing being, as Justice McLean said, he is amenable to the laws of God and man, and he is destined to an endless existence. He will not decompose when his life will not end even when his material existence is coming to an end. All that came into the moral understanding of why human beings are the bearers of rights and what we're trying to protect here. So all that is at stake. You can do many things in taking a different path in moral legislation in the states. But at some point, the question has to be raised. Are you doing something that just severs the connection to those deep, minimal moral understandings that were there in the first place to understand what we're about here? Why did we form this regime? And when a government becomes destructive of those ends for which it was constituted, then there's a ground for people dissolving that government and creating something new. But that's what we're after. So my concern, Tim, is
you're speaking my language there. Sorry, I didn't mean to. Yeah, that's what I'm saying. But there seems to be a fundamental unwillingness on the part of natural law jurisprudence to speak to why does it need to be so big? Because it's been proven time and time again via the pure growth of America into a consolidated.
Yeah, that's the other point I was trying to make with you. It could be large, but the point we're neglecting is
why must it be? Why is there the obsession with largeness when that is?
I'm with you. We didn't have to take over Hawaii, did we?
Why can't these states be individual state, which what they truly were under?
Well, let's them hive off and form a state of their own somewhere. Bring back secession, you might say. But I think the fault is
Virginia retained the right under, as it came, the most important state in the union retained the right.
Some friends in Texas, maybe Texas and Florida. Maybe I'm sure I'm going to move to Florida.
Yeah, we can move there together. If they secede, I would go.
If they secede. You know, Jerry Seinfeld's like, his parents turned 65. They moved to Florida. They didn't want to go, but it's the law.
White hat, white shoes, get in the car, go, Paul. That's what.
Okay, but look. I think the fault is, there's some advantages of being bigger and sort of as Madison thought. It's harder for any strong local business like Kodak or DuPont to take over the whole country. Okay, on the other hand, what's lost here? The utter loss of understanding that citizenship involves moral terms, and that it's critical to make people understand what it is they cannot claim in their standing as citizens, what the government cannot deprive them of course, their standing as citizens. They've got to should understand something that, like the court strikes down this policy in New York saying that before we give resident aliens a subsidized tuition, that we ask when they're going to become citizens. The court strikes that down. Well, let's say it matters whether you are funding the education of an engineer in the 30s who wants to go back and become an engineer for Hitler. You say, these are grown-ups. Why do you think it's unfit to ask grown-ups about the nature of the regime that claims their respect and commands their allegiance as a moral entity? Why is that moral question somehow just out of bounds anymore? It has to do with the fact of a libertarian trend that's been at work since progressivism in Republicans as well as Democrats. It's not the fault of largeness itself. It's a fault of a moral erosion within the scheme. And that was not the fault of the founders, not the fault of Lincoln. It's a fault of the later generations. But now the question is, why can't we recover it? Some people say we'll need a great awakening. Others of us say, look, we have the document. We know the teachings. We know what's going on here that's counter to the teachings left us by Wilson, James Wilson, Marshall, Alexander Hamilton, and so on. We can recover those things. Those are within the possibilities of recovery. So why not try to recover the moral understanding, which say we're going to break off into regimes where we're not entirely clear on whether it's founded on the notion of human beings as rights-bearing being, or whether it's founded simply on the right of the local majority simply determine the terms on which they wish to live, whatever those terms are. We're going to have to face those kinds of questions.
Well, natural law tradition is univocal up to Madison Federalist 10, that citizenship must be small, whether it's 50,000 in a polis, in a polity, or 100,000, it's univocal. So as long as we just acknowledge that up until Federalist 10, where people are like, you could have a 1 billion person republic, or whatever, that's not literally what he said. People are like, that's a fundamental, you're controverting a fundamental element of what a res publica is. Aristotle and Plato were arguing whether it should be 50,000 or 100,000. That you're trying to set aside. Well, it can be big and let's not debate it. But at the same time, or actually one remark before that, Dr. Arkes, you said citizenship involves moral terms, as if these are separate propositions like two ships that pass in the night. Citizenship does involve moral terms. I'm not, in strict terms, a libertarian at all. I'm not making the argument for legal positivism. Citizenship, you bet, involves moral terms, but it only does so on the basis of Dasein, being there. Like if my republic were my neighborhood here, I would be very involved. I am involved. I want to make sure we had a Dollar Tree pop up over here. I was ready to go. Hey, look, if I need to chip in $500 or $1,000 so that all the residents of the neighborhood can buy that property and keep the Dollar Tree from coming in, I will do it. If I need to go plant trees there, if I need to plant a garden there for some tragedy of the commons reason that the it's not private property, whatever, I will be involved, because locality is the forum by which I exercise my moral agency. Conversely, if something's happening in Bangor, Maine, or Portland, Oregon, it's a simple ontological, and here I mean geographical fact, that there's no forum for me to exercise my moral agency. Okay, there's BLM and Antifa are running naked through Portland, Oregon. My cousin lives there. I care about her, but there's nothing for me to do. I mean, there's simply no means by which I exercise my moral agency. This is why Pius XI comes back to subsidiarity. Citizenship is a moral proposition. The libertarians are wrong about that. I agree with you there. But I don't see how you're excising from this the ontological claim of being there. You need to have a republic that you can kind of survey.
You're right. But you're describing a regime in which we say, yeah, right. We don't want people. We want people to share things with us. And they may not include Black people. They may not include Jews. Sometimes they may not be Catholics. Well, we were able to live with that. Rhode Island, when George Washington gave his letter to the Hebrew congregation in Newport, Jews were out voting in Rhode Island. Yeah, we can do it that way. That's not the way we decided to do it. And so the question is going to be again, and whether there are these moral terms. You raised an interesting question about contraception, for example. Bring it back to the matter of prudential compromises. Justice White, in that opinion, said, well, we could do this for protect that right of contraception for married people. But, many other things open. You can still restrain it for minors. You can still, I would think, still bar contraceptive devices in bathrooms for taverns, for one-night stands, and so on. In fact, you could possibly, people asked me about this last week. Yeah, there was a rationale for the laws on contraception because, as we know, it changes the whole the intentions involved in sexual engagement and coupling with. But the point is now, have we reached the point that is so comparable to like abortion with rape or interracial marriage in the 1850s, where suddenly our people are going to have to make a concession on that matter of conscience, shearing away, as you say, from a really compelling moral argument for the sake of making a prudential accommodation with people as the way we find them right now. It's an interesting problem you pose there. And it's a problem that it's a serious question for us now, who think, as I do, yes, there is a serious argument that would justify those early laws on contraception. So what do we have here? Oh, by the way, Tim, I did make an engagement for physical therapy at 3 p.m. We're going to have to, this is, I hate to make a judgment of it. This is the best, most enjoyable conversation I've had on, this is the best conversation we've had on the book.
Well, thank you.
And you are really terrific. And I wonder if we could continue this conversation. After we fill up our minutes here, whether we can do this again, because
we should.
You have an important perspective here, and you deliver it well.
Thanks. Well, you're a hero of mine, and so these are questions I've wanted to ask you for a long time. A hero whom obviously we have disagreement within agreement. What I want to, I'll give you a closing word, Dr. Arkes, because you have to go to your appointment. This has gone long, but I do want to tell folks out there that Dr. Arkes has a new book out. It's the one that I was citing from, and it's called Mere Natural Law. And unlike some of his other books, this is a problem, guys like us that are involved in jurisprudence and ontology. We have to make sure that not all of our books are, that some of our books anyway, are popular level books. Mere Natural Law is, I think, by most estimations, Dr. Arkes's most popular reading level book, where he explains these things.
They used to say that Socrates brought philosophy down out of the clouds to bring it to bear on practical judgments, right and wrong. And what we're trying to do is bring natural law down out of the clouds, where people think it's some airy theory that doesn't really bear on the judgments, the practical judgments we often make every day. And people do this every day. A couple of years ago, everybody in my building were put out on the grounds because the fire department was fighting a fire in the building. We were vexed. Our natural liberty to our liberty to go back to our apartments must be that no one thought that our rights were being violated, because they thought, okay, our liberty was being restricted, but there was a patent justification to protect our lives. I
Sure.
see a youngster about to go into the subway in DC with a bike, and I say, my gosh, you can do that? He says, but not during rush hours. He understands that his liberty is being restricted, but he understands there's a justification for it. My point is, these are the way that people naturally frame these. They do it every day. There's nothing arcane about this stuff, nothing esoteric. I drew on mere natural law for the sake of drawing on that part of C.S. Lewis, with this thing, when he recognizes you can find even in the conversation of children, the rudiments of moral reasoning. They move beyond likes and dislikes. They want to argue about right and wrong. They assume that the conversation makes no sense unless there are standards of judgment to tell the difference between plausible and implausible, true or false answers. And I want to try to show in this book, going back with Thomas Reid, to say those precepts of natural law, moral reasoning, that the ordinary person not only those precepts of common sense that the ordinary person not only has to knows, but he has to know in getting on with the business of life before he can start trafficking with theories. So before the average man would start bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. So what I've tried to do in the book is to bring things back to the things that ordinary people understand, which some of our lawyers, like Anthony Stevens turns himself into a woman, and the rest of us are supposed to be obliged to respect that or put ourselves in legal peril and our employers in legal peril. And the conservatives are trying to find out what did it mean, sexual discrimination mean in 1964? They're looking at the text, but they don't think of going beyond the text to the objective truth of what constitutes sex. Now, as the Congregation for the Doctrine of Faith pointed out years ago, there's not always been in Italy, there's not always been in Hungary. As long as they're human beings, there are men, must be males and females. So the question is, why is it that lawyers schooled in theories of statutory construction come out with a judgment that any ordinary man could see as imbecilic? So that's the nature. That's what we're trying to do here. Try to bring it down out of the clouds and point it out that the judge can't get through his day without using these precepts of moral reasoning. And to ask whether he could do it is like asking, can I order the coffee without using syntax? I mean, it's woven into everything he does. And it's so woven in that we're hardly even aware that we're using it. But listen, thanks for giving me that. But I promise you, I'll come back and do more, because you are terrific. And this is one of the best conversations we could have had about this book.
Well, the book is, thank you so much, Dr. Arkes. It's been a legitimate honor. If you need to duck out, you could just hit end. I want to tell people the book is available for order now on Regnery Press. Regnery is where I have my fourth book. It's Mere Natural Law. When will copies arrive if someone orders on Regnery today? It's an important book.
I suppose within a week, probably get it in a few days.
Okay, so it's not in the pre-order phase.
Oh, no, it's out. It's out.
Okay, it's out. When was pub date?
May 2nd.
Okay, it's just May. I thought it was June 2nd. I knew it was something second. Okay, so Mere Natural Law, Dr. Hadley Arkes, one of the top, I said top 10, really the top 3 or 4 anti-abortion guys that actually has gotten stuff done. We might disagree about the legal reasoning behind Dobbs, but at the end of the day, this hero here is one of the guys that really got Dobbs done. We're disagreeing about what it means, but what's more important, you actually helped to get Dobbs done, and you got the Born Alive Act written. So you're a great hero, and I do hope you'll come back. And this is an important discussion we're having, 2 conservative Catholics, about what is to be done now in this deeply, deeply consolidated American empire regime. I called it Regime 3.
You've got so many great points, Tim. You know, it's as to take that line from Shakespeare in Love, you are wonderful. And what you and your lady have done in raising those children has just been just a terrific story for us all. I'm sorry I have to dig out for this therapy for my shoulders. But if we give you a kind of a rain check, do another dip in with you, because this has been so engaging, and I'd love to do it again with you.
God bless you, Dr. Arkes. Yeah, just if you hit end on your end, I will say a closing word here.
I hit leave.
Yeah, just hit leave.
And you say, don't believe anything this guy just said. Okay.
God bless you. No, I'm not
Bye-bye
going to.
now. Bye-bye.
Bye-bye. So that is a great conversation with a man whose writings I've read for 20 years. And that's interesting. And you can disagree passionately about the justifications by which an anti-abortion hero has gotten his goodly stuff done. And that's what we're doing. I would simply, he adverted, Dr. Arkes, to a C.S. Lewis quote. I was also going to leave with the C.S. Lewis quote, Parish Orphans and Retrogrades. You hear me say this one often. Put first things first, then you get second things tossed in as well. If you reverse them, if you put second things first, you get neither. And I would say when we were attempting from adverse points of view, Dr. Arkes and I, to describe why it's a grave evil for a judge in Washington, D.C., a federal judge, to tell a man in Connecticut that he must be able to use contraception, that his state cannot make it illegal for him to use contraception. Though we agree that, we disagree why. And I would advert to the C.S. Lewis principle, the first things first, second things second, and you get both. And I would say subsidiarity, this first Catholic principle of government, the idea of it's immoral to adjudicate or legislate matters that are not local. If you put subsidiarity first, it's a procedural reason why it's immoral to legislate from afar. And if you honor that commitment that Pius XI gives us in Quadragesimo Anno procedurally, do not attempt to legislate from afar. And moral legislation is good. Dr. Arkes and I agreed on that. You want moral legislation. What violates the principle, I should say, of subsidiarity is legislating morally from afar. If you violate the procedural and you have federal judges making it illegal for the state of Connecticut to make contraception illegal, or a DC judge makes it illegal for, whatever it was, Texas, to make abortion illegal, or you make it illegal for the state of Georgia. Notice these are all red states. Illegal for Georgia to make pornography illegal, or in the case of Skittles, sodomy, Texas. Then you're violating the procedural principle first, subsidiarity. And the second principle is they always come out wrong substantively. On the substantive matter, you never have the phenomenon of violations of procedural subsidiarity where the federal overarching judge is going to come in and tell localities what's what, doing the right thing, the Catholic thing. You're never going to have a ban on contraception, porn, sodomy, gay marriage, abortion from the top that gets it right. And I'm adverting to the C.S. Lewis principle. That's because they've already violated the first principle of good Catholic government, which is the procedural one. Do not attempt from afar to adjudicate or legislate a moral matter that should be, according to nature, legislated or adjudicated locally. That's why I was going to ask Dr. Arkes this in closing. That's why you never see that. You never see a 14th Amendment provision that does something good. You never see a violation of subsidiarity that's like, okay, well, procedurally, that's bad. You're violating what Pius XI called a grave evil. But substantively, we like the result. You never see that. It only works one way. Only the left uses the procedural violation of subsidiarity for the substantive violation of virtue. I would defy people to come up with one instance where from 5,000 miles away, the nerve center, Washington, D.C., comes out with a law top down that a Catholic, a faithful Catholic, would like. Parish Orphans and Retrogrades, God bless you all. Thank you for watching this extended edition, because it was kind of a 2-hour debate, friendly debate with one of my heroes, Dr. Hadley Arkes. important questions for now that America is too big, too immoral, too flabby, too unchristian. What is to be done? Dr. Arkes represents the point of view that top-down legislation and adjudication is good. We just need a Catholic to do it. I say, no, it needs to be, we need to honor the principle of subsidiarity and do things locally. And who knows what that even means. I've done other shows on it. If you believe this, though, go to realestateforlife.org and this is why I'm so big on realestateforlife.org. Get out of your blue state, which is really more your republic than the United States of America, your state. Get out of it and get to a red state like I did. I went from a very blue state in California to a very red state in Mississippi. I voted with my feet. And now these issues of the states being the fora of experimentation is lived in a daily way, in an enjoyable daily way by someone like me and my family. And I was trying to intone this to Dr. Arkes. Well, just get out of a blue state, get to a red state. This is my real republic. Mississippi, not really America anyway. It's too big. And now I enjoy all the fruits of living in a Christian place, whereas I didn't when I lived in California. It's very real. It's an ontological issue. It's not merely some theoretical issue. It affects me down to my being. Go to realestateforlife.org today and get out of your blue state, get to your red state. There couldn't be a more on-point advertisement that I do at the end of this show about what is the nature of citizenship, what is the nature of political virtue, what is the nature of the union, how small must a republic be, how big can it be at its boundary conditions. That's really where this talk was going with Dr. Arkes. I promise I'll have him back on the show if he'll come. God bless you all, parish over the retrogrades. Have a great one.